I'm attorney Carl Barkemeyer. I have defended clients with criminal damage to property charges in Louisiana for 17 years. I have seen many different fact scenarios when it comes to this charge. I know which defenses work and which ones don't. As you're watching this video, keep in mind that every case is different, since there are different alleged facts, victims, prosecutors, etc. Now, I put this video together as a general guide on the laws regarding criminal damage to property in Louisiana. Criminal damage to property is the intentional damaging of any property of another without the consent of the owner. Basically, you can't destroy someone else's property, whether it is their house, apartment, car, boat, etc. Many arrests for this charge occur when couples get into fights and throw each other's cell phones, completely destroying it. Since cell phones cost so much these days, the alleged victim will call the police. Another common example is when a couple gets into an argument and the defendant gets locked out of the house or the apartment, then breaks the door to get in. That value of the damage to the house or apartment will determine if the charge is a misdemeanor or a felony. Criminal damage to property occurs in the bar scene as well. The defendant may get a little too drunk and cause damage to the bar by breaking windows or other property. In this scenario, there will usually be a disturbing the peace charge associated with it. Another common type of criminal damage charge is vandalism. It is more common for younger defendants to get charged with vandalism. Breaking into a building and destroying the property inside would lead to a criminal damage charge. Or if the defendant decides to spray paint the victim's car or key the sides of the car, he would probably be looking at a felony simple criminal damage to property charge. There are two primary criminal damage to property charges in Louisiana. They are simple criminal damage to property and aggravated criminal damage to property. Aggravated criminal damage to property is always a felony charge. Simple criminal damage to property can be a misdemeanor or a felony depending on the alleged value of the damage. You can get jail time for criminal damage to property, although probation is allowed if the judge decides to order it. The punishment for criminal damage to property varies based on the alleged value of the damage. If the damage is less than $1,000, the simple criminal damage to property charge will be a misdemeanor punishable by 0 to 6 months in jail. If the damage value is greater than $1,000 but less than $50,000, the charge becomes a felony punishable by 0 to 2 years in prison and/or fine of up to $1,000. If the value of the damage is over $50,000, the defendant can face a prison sentence of 1 to 10 years and a fine of up to $10,000. In addition, the judge can order the defendant to reimburse the victim for damages. As you can see, this charge gets worse as the value increases. There are many factors that go into a judge's decision to order a jail sentence versus probation, such as the facts of the case, the victim's impact statement, prior acts, prior convictions of the defendant, and the perceived threat that the defendant could do it again. The criminal charge of simple criminal damage to property is the act of damaging someone else's property without their consent by means other than fire or explosion. If fire or explosion is used, it would become an arson charge. Aggravated criminal damage to property occurs when it is foreseeable that human life might be in danger. For example, if the defendant shoots up another person's car or house with no intent to kill or injure, he may get arrested for aggravated criminal damage to property. Another example is when the defendant uses the vehicle he is driving to cause damage by running into another car or property. The prosecutor would argue that if someone was present, their life could be in danger. Basically, the main difference between aggravated and simple is that the means of committing the damage during the act of the simple criminal damage probably wouldn't endanger another's life. With aggravated, if someone happens to be present, their life could be in danger. If you are the victim in a criminal damage to property case, then you have probably already called the police and made a complaint. The case will then go to the prosecutor or DA's office and go to court. You will need to be able to prove that damage was in fact done to your property by the defendant and that he did not have consent to damage the property. You can take photos or video to show the extent of the damage to the property. Also, you may need to prove the value of the property damage. For instance, if the cell phone repair bill was $500, then you would need to have a receipt or an estimate showing that. You can beat a destruction of property charge on the facts if the victim and prosecutor cannot prove an essential element of the charge beyond a reasonable doubt. They must be able to prove the following. 1, that the property damage occurred. 2, that it was intentional. And 3, that it was without the consent of the owner. You can beat the charge if the victim cannot show that there was even damage caused by the defendant. For instance, the damage may have been pre-existing. Maybe it was caused by someone else or the victim herself. You can beat the charge if there was no intent to cause the damage. If it was just an accident, such as a car wreck, then we'd argue that the defendant shouldn't get convicted. The victim must be able to prove that the damage had value. If there cannot be a value placed on it, then maybe there really is no damage. At least not enough to support a felony charge. As you can see, criminal damage to property charges can be very serious, and oftentimes they will be accompanied by other charges as well. But we know how to successfully defend these types of charges. If you or someone you know has a criminal damage to property charge, feel free to give me a call. I'd be happy to help.